When I was younger, my mother used to tell me stories about the Vietnam War. In refugee camps, they would often label themselves ghosts because they knew that every day that passed, their chances for getting into Canada slowly dwindled and their hope for a better life disappeared. My name is Jasmine, and today I come before you, Steve, as a fourth-year political science student with a research specialization to pledge to use my JD candidacy to give back to public resources in law, such as legal aid and pro bono services, so that no one will ever be labeled a ghost ever again. These people were given the label ghosts because they felt neglected by a system that constantly oppresses them, that will never ever hear anything that they say, that their voices will never be heard. When I was working on a moot court submission with a teammate, I saw firsthand how this happened for Indigenous offenders who are systematically overrepresented in the criminal justice system. The GLAD report is supposed to help people. It's supposed to act as a mitigating factor in sentencing submissions. It's supposed to encapsulate what each individual who is Indigenous has gone through and the systematic oppression and the ways that that has affected them in a different way. And yet it's used as a one-size-fits-all puzzle piece today for all Indigenous offenders. And we need to change that. There was a case that we worked on in moot court that encapsulated one particular Indigenous offender who was impecunious, they said, who was living on welfare at the time that he was arrested and charged with robbery. And surcharges were slapped on top of him, despite his impecunious status of being addicted to alcohol, of having mental health issues, of being on welfare and not having the thousands of dollars that a victim surcharge needs in order for him to give and give back to that and provide for himself and for whoever was living with him at the time. And when I saw that incarceration was the solution to someone not being able to pay for their victim surcharge, I saw a problem with the system. The criminal justice system does not lend the sympathetic ear necessary to these people to understand how to best help them. And we need to change that. Legal aid should not be 10 clicks away. Whatever resources that are publicly available or allegedly publicly available to these people should not be 10 phone calls away. It should not be a click away. It should understand that these people are impecunious and that they are living off welfare, and it's not about the money. It's about helping people. It's about making sure that these people's voices are heard because they are lost in the process. I've seen people beg for defense in the criminal justice system and not being given it, because they have not applied for the legal aid service necessary online. But when you think about it, applying online in and of itself is a luxury, because that requires technology. That requires understandings that they might not be entitled to because they don't understand how the legal process works. And so when they are on their last leg, the last thing that we need to do is to kick them down further. And so for these people, it's not about the LSAT. It's not about understanding reading comprehension or any of that. Steve, I come to you with the problem that Canadians are facing, and that is the overrepresentation of minorities in the criminal justice system, for example, who are experiencing a disproportionate effect in their workplace, their livelihoods, and being able to prepare and navigate systems that they should be entitled to. We in the Canadian justice system and in general have a constitution that guarantees people rights. So why is it always a question of defining what those rights are entitled to for those particular minorities? For youth, such as the Jordan submission, where we have questions of whether or not they should be entitled to those foundational Section 11B charter rights. For people such as impecunious offenders, who again, we question whether or not they are entitled to specific rights in the charter because they are of impecunious status. Because why should those rights apply differently, right? Why should they? As a system, we need to acknowledge that these people are going through systematic issues and have been oppressed, and we need to start giving them the guaranteed rights that they are guaranteed to. Thank you for listening to my submissions.
Thanks for tuning into the show. Please subscribe if you haven't done so already to be notified of new episodes as I release them, and feel free to reach out if you need anything at all as you move forward with your prep. I'm happy to help however I can. In the meantime, I'll wish you all the best and take care.